Thank God. We're recording in progress. Welcome back. We hope you enjoyed your second day of the program, and we're going to quickly move on to our last day today. First off, we could not do this without our sponsors, so we're going to have our Friday sponsor come on and say a little bit about who he is, what his company does, and I'm going to bring Andrew Spring from All Seasons North Roofing and Waterproofing. And I'm going to ask him to Hello, Andrew.
Good morning, everybody. So I'm Andy Spring, All Seasons North Roofing and Waterproofing. We are a full-service roofing contractor. We really like to focus on service work. So a lot of times people say, oh, I was afraid this job would be too small for you. It's not. We're doing plenty of big jobs, but we also like to create relationships with our customers and like to be there, help them prepare a CapEx budget for when the big work is ready to be done, but also help take care of your roof in the meantime. We've invested in the past year and a half or so in a new customer resource management program that's really helpful for us, and that allows us not only to schedule the work and the guys to do things in the field, like give us immediate feedback with pictures, but it really allows us at the end of the year to collect all of that data and then get back to our customer and say, hey, we spent a lot of money on this building. Maybe we need to think about doing a maintenance program over here. Had a lot of leaks there, or maybe it's time to start thinking about re-roofing. So, kind of being proactive about roof maintenance and repair rather than reactive. So, yeah, that's about it for us. Give us a call. We're happy to get started on anything.
Thank you so much, Andy. We sincerely appreciate your sponsorship, and thanks for coming on this morning. Please make sure to post your information to the chat for our attendees, and then I will also be sending it out after the program.
Okay, will do. Thank you.
Thanks, Andy. All right. Please consider our sponsors when you are planning projects or need help in your community. I just asked Andy to share his information to the chat, so be sure to grab it from there. $5 Starbucks gift cards are also a big thank you to our sponsors. You'll be getting those this afternoon along with your certificate and links to all of the 3 session videos. Housekeeping, we are recording this meeting. Please keep your microphone on mute. We will be taking questions via the chat function at the bottom of the Zoom screen to be answered at the end in the order that they were received. We may also take questions live, barring time constraints. Handouts will be sent out this afternoon. If you don't get it, please respond to any of your registration confirmations that will come directly to me, and I can help you out. I am going to be sending out the National Board Member Toolkit as well this afternoon. You should have gotten it for the first 2 days. It is a great reference point. We will not be going through it in the order that it is done, as California law is significantly different than most of the national law. Our next session, CID Law and Rule Enforcement, is being presented by Jasmine Hale of BERDING WEIL and DARREN BEVAN of BAYDALINE and JACOBSEN LLP. Please welcome Jasmine and DARREN.
Hello.
Good morning, everyone.
All righty.
Step 1. Should we start the slideshow?
We're going to start with the slideshow. DARREN is going to be our pilot today. And while he's getting that up and going, little disclaimer, we're giving you information for educational purposes. We're both lawyers, of course, but we're not actually providing you with legal counsel today. So if this prompts questions, reach out to your friendly community association attorney and they can give you the specifics. So with that said, we are going to press on. Like Rachel said, we are covering CID, common interest developments, laws, and rule enforcement. DARREN and I are going to be covering some big topics, meaning like in terms of importance and size. We kind of joked when we got this presentation, we were like, 50 minutes, that's adorable. We'll never get through that in this amount of time. So strap in, hold on. We're going to cover things, pretty quickly. and we will look forward to questions at the end. For a macro view, I'm going to go and do the overview. Darren's going to cover governing documents, like what they are. We are both going to tag team on board duties and fiduciary duty, the biggest topic. I'm going to cover the roles of officers and committees, and then Darren and I are going to tag team on rules, the adoption and creation of them, and then the enforcement of them, the second big topic for today. So, a few important considerations for common interest living. We are a unique entity because we've got, you know, like Apple, it sells services, it sells widgets, you know, law firms, we sell services. Community associations are kind of an amalgamation of a bunch of different things, and that is, you know, in my opinion, truly unique. We're a corporation, not always, but most of the communities that we work with are actually incorporated. Makes sense from a liability protection standpoint. We are, associations are actual businesses. You generate revenue. It comes from your members' assessments. You have, you know, board has duties. There's protocols to follow. In that regard, it's not really different than GM or, you know, pick your favorite corporation. Homeowners associations are actual real estate projects, and, you know, perhaps most important, they're communities. And that's kind of something that comes from within the community and the tenor of the, you know, homeowners and how they, you know, elect boards and the, you know, image that they create amongst themselves. And it's also from external sources. You know, you can be well known, you can be notorious. Darren and I have worked with clients of both stripes and everything in between. So we always like to start this type of a presentation with a, you know, call out to the uniqueness of common interest communities for that reason, because sometimes it gets easily overlooked by your members that you're a business. And, you know, we're always trying to project professionalism in board interactions with each other, with the members, and certainly with all of the, you know, providers that help service these communities. Okay, so types of communities. There are four. Remember this, 4 common interest development types. We've got stock cooperatives, condominiums, planned developments, and community apartment projects. Those are the designated common interest developments. Stock co-op, that's a corporation, owns the building. All the members are shareholders. They have, you know, they have proprietary leases to exclusively occupy a certain type of, you know, a certain unit in the community. Not so common on the West Coast, definitely more common in the city, and certainly very common with my historic communities that are like from the 1910s and 20s. So we've got condominiums. It's a cube of air inside the walls and an undivided interest in the common areas. So there we go. Planned development, some people will call them PUDs, like PUD, but it's actually planned development. This is where the homeowners own the lot and everything on it. And the association typically owns the common areas, and all the members have like a non-exclusive right to use and enjoy the common areas. Sometimes it could have a common ownership of common areas, but not often. And then last but not least, community apartment projects. Darren, have you ever had one?
No, never met one. I'd love to. I've been interested.
You've probably got what, like 50 years of legal experience on this call. Not a one community apartment project.
No,
so
not popular with young people. So
those are common interest developments. And then we've got types of communities. We've got mixed use, that's your residential and your, you know, commercial glommed on together, typically in urban settings. Master association, it's where one, you know, community rules them all, kind of like the One Ring. Kidding. Shouldn't make a reference to Sauron in connection with an HOA. But this is where you'll have one large community that has sub-communities, sub-associations, villages. They can have different words that are governed by a master declaration and often sub-declarations that apply to the community particular. And then we've got specific purpose communities. You could have equestrian, lake, you name it, but they're generally a type of planned development or a mixed use community that's organized around a specific type of use or purpose. So Darren's going to take it up next with a discussion of legal docs.
yes, we can get the slides to move forward. So when we talk about the legal documents, also many folks call them the governing documents. So first thing to always remember is that both state and federal law supersede the requirements of our governing documents when there is a conflict. And so if there's a conflict between an association's governing documents and the law will generally prevail over your governing documents. Also remember, like Jasmine was speaking to, there are different types of associations with different types of documents and requirements that apply. And so when you're thinking about the governing documents for your community, think about what type we are. That's why it's important. And then based on the type, generally is going to drive what the documents might say. So a condominium obviously would have different rules than, say, a planned development where an owner owns their lot and the association owns the common area. In a condominium, all owners own jointly the property of the association and then have ownership of their individual unit. And like a condominium, a cooperative is similar to that, where the association owns all of the land, all of the improvements on the land, and then each member has a membership right to occupy a particular home in that community. But each one will have different documents that drive what is necessary and appropriate for that particular community. When we start thinking about governing documents, it's one of those jargon words that we use all the time. But what does it boil down to? It boils down to a series of documents that are either recorded with the county, filed with the state of California Secretary of State, or as a private document of the corporation. And so we start with the first, what I would call the driving force of an association, which is the Declaration of Covenants, Conditions, and Restrictions, which we all lovingly call the CC&Rs. Right. So most folks don't call them a declaration. Most people call this document CC&Rs. This is a legal contract. It's a binding contract between each and every owner of the association to set the ground rules for how this association is going to run. It is, covenant is a key word in the whole Declaration of Covenants, Conditions, and Restrictions, because in fact, a legal contract that is more than just a contract. It's a covenant, a promise to do things and to not do things. So CC&Rs usually contain provisions that say, I promise not to alter the exterior of my home without first getting the association's approval. Or I promise to pay the assessment to the association each month or each quarter or each year, depending upon the circumstances. And when we think about the CC&Rs, not only are they this contract, this covenant to do things and not do things within the community, it is a public record, meaning it is recorded with the county where the association is located. Any person can go and request a copy of those CC&Rs, whether they're an owner or not, but most importantly, because they are a recorded document, it is applicable to all current owners, future owners, etc. Because in essence, the CC&Rs use this magic word that we love in the law, and that is the CC&Rs run with the land. They go from owner to owner. As they're amended, those rules and restrictions can change, but ultimately they apply to every owner throughout the life of the community. Also remember that when you're thinking about the CC&Rs, it always requires a member vote unless there is some exception within the document. And so generally speaking, CC&Rs, in order to change a term, a condition, a restriction, the association's membership must vote to approve. In most communities, that's a simple majority of the members, but in some communities, it might be a higher standard. Perhaps 67% of the members must vote in favor of any changes. Or as I have one client, they require 80% of all members to approve any changes to their governing documents. But the nice thing is, the law gives us an exit or an off-ramp in that if you cannot achieve at least 50% of the members voting to amend the CC&Rs, but you cannot achieve that supermajority requirement, you can petition the court to have that requirement reduced. So CC&Rs, when you're thinking about how members use the land, what restrictions might exist on the land, this is the document as a director you go to look to, right? Are they allowed to grow 45 cannabis plants in their backyard? We would look to the CC&Rs to see whether or not that is in fact a violation. The next document we're going to talk about is the condominium plan and or subdivision map. And so this is something that is different from the CC&Rs. Again, a public record that is recorded with the county where the association exists. But the condominium plan is that. It's basically a two-dimensional drawing of the condominium. Each one of the units, the common area, etc., is drawn in 2 dimensions on this map that is then recorded with the county. That condominium plan also includes particular terms and conditions, which the board should be aware that this, if you are in a condominium community, that this condominium plan exists, and that it may have further clarification as to where the units are in terms of the overall development, what components are inside the unit, what components are outside the unit. Much like a condominium plan, the subdivision map is another 2-dimensional drawing, but this time instead of drawing units in common area, it's drawing the lots that exist on the land. And so subdivision maps are mandatory as a matter of law, meaning you cannot subdivide land without a map being recorded. You could not take a large lot and reduce it into a bunch of smaller lots in common area without that map being recorded. And these are generally all done by the developer at the time that the community is created. And when we're thinking about both the subdivision map or the condominium plan, like I say, many times you're looking at it to determine certain responsibilities, whether that's the owner or the association, or generally what exists on the land, for perhaps easements. Maybe it's an emergency vehicle easement or some other type of benefit that exists within those documents. So subdivision maps are always required. Condominium plans are always required for condominiums. And generally, though, as a director, you may not be looking at this a whole lot because these are not key documents to governance and day-to-day operations. But you should be aware that these exist. Know that they are in public record, meaning they're with the county recorder. And there are times that these are necessary to prove or to determine certain aspects of the community as to the land or the condominiums. We now move to one of my favorite documents, the Articles of Incorporation. I like to say it's one of the least important, but most important of all your governing documents. Articles of Incorporation are like your birth certificate. You need to know that you have Articles of Incorporation. You need to know where to find it. But how often do you really look at it? Not very often at all. But what the Articles of Incorporation generally do is they create the corporation, much like a birth certificate, meaning it documents with the state of California when filed with the Secretary of State, giving our corporate purpose, our legal name, our location and addresses, our agent for service of process in some cases, and essentially lay out this broad purpose of the corporation. It is a public document filed with the Secretary of State. So anyone in the state of California can look at the Articles of Incorporation. And generally speaking, to amend this document, it's a 50% vote of the membership along with the majority vote of the board of directors. But you need to look at the terms of that document in order to determine how is it amended. But as a director, typically this is not a document you're going to look at on a day-to-day basis to answer questions about, well, what do we do here? What should we do? What shouldn't we do? But there are times, for example, when you're opening a bank account or you're borrowing money, that your Articles of Incorporation become very important because it does document that we are, as in most cases with associations, a California nonprofit mutual benefit corporation. We move on to the bylaws. Bylaws, again, are one of the critical documents for the board. So the CC&Rs are very important for the board to be familiar with. The bylaws are just as important. Unlike the CC&Rs, the bylaws drive corporate governance, right? Jasmine spoke to that we are a business. When we think about how does this business operate? How does the association govern itself? Who is a member? What are their voting rights? Who can serve on the board of directors? How many directors do we have? What positions do we have as officers? All of these questions are answered by our bylaws. They give us guidance as to the association. They also include powers and duties, obligations of the board of directors, and set forth all the election and qualification procedures for your board of directors. And so, again, what I would suggest is, as directors, if you're serving on your board, that you become familiar with this document, understand generally what the powers and duties of the board are, understand the nature and governance of the corporation for the benefit of all. And then finally, talking about the rules and regulations, which we're going to go into more detail in just a moment. But do keep in mind that we can take those CC&Rs, we can take those bylaws, and based on those documents, we can create what are called rules, basically further clarification to guide the day-to-day living within our community. You know, I always like to use the example, say your association had a restriction in your CC&Rs that said members may park on their driveway for a reasonable period of time. What the board can do is use rules to clarify what is a reasonable period of time, so that way the members have guidance as to how the board will interpret that clause in the CC&Rs and further clarify those obligations of the membership. Also, there are times, for example, associations must adopt certain rules, and we'll talk more about this later, but you may have to adopt election rules, a collection policy, which is another set of rules. All of these are adopted by the board through a board vote. Every other governing document we spoke about so far, meaning the CC&Rs, the subdivision map, condominium plan, articles of incorporation, all require a vote of the membership, whereas rules are adopted solely by the board. More on that later. And then finally, we have resolutions, minutes, and resolutions that are adopted by the board. These are documents maintained by the association to ensure that we have a record of what the board of directors has done, or in the case of, say, a membership meeting, what the members have done. And so maintaining resolutions, minutes, etc., that document the actions of either the board at its meetings or the membership at their meetings is critical to governance of the corporation. With that, we're going to move forward and talk about the CID board member and fiduciary duties and responsibilities. With that, we turn to Jasmine and the rights and obligations.
There we go. So now we've got a good foundation on the docs and the structure of our community association. So now we're going to talk about the different stakeholders and their different rights and responsibilities. And it really does take a village to operate our communities. So first, we've got the developers. These are the entities or the individuals. They develop, they create the common interest development and the association. They create all of the initial governing documents. So all those rights and restrictions, they are the ones that made the choices, or maybe their attorneys, to put them in or not. So they have a duty to construct the community association in accordance with applicable laws and building codes and standards. And when those standards aren't met, the association and the homeowners have a right to pursue developers for the claims against them for faulty construction, or to compensate them so they can make repairs to their respective areas of maintenance and control. So it's called a construction defect action. So developers create the community, but they also need to build a good one. Then we've got the homeowners. These are the members of the association. These folks are the record title holders. So your name needs to be on the grant deed. You could have your spouse who's the record title holder, but if you're not on the deed, you're not actually considered an owner as a matter of law, and certainly under the governing documents as well. So it's just important to understand that, you know, spouses and family members, they may have rights, but if they're not reflected in the record title, they are not considered the owner. Why does who's on title matter? It's because owners are the individuals under all those governing documents that Darren talked about, who have the right to exercise the membership privileges. They get to vote. They have to pay assessments. You know, so those are the duties and responsibilities that the homeowners have. So then we've got board members. These are individuals who are either elected by homeowners through a director election, or we're still on the other slide. He was just getting so excited for this topic.
Remember, we have a long way to go and a short time to get there.
I know. So we've got board members. They are the folks that operate the common interest development. They've got powers and duties. I'm going to cover them a little bit more in a second. And then certainly Darren will dive into fiduciary duty. Then we've got the officers. Officers are roles that are assigned by the board of directors. Typically, they're going to come from the board, but it's going to depend on what the bylaws say. And so they serve at the pleasure of the board. I'm going to do a deeper dive into the different types of officer roles, but think of officers as task doers. because that's really what they do, is fulfill certain tasks. And then we've got committees. They are also appointed by the board. So just like officers, they serve at the pleasure and the board can change them. And I'll go over different types of committees in greater detail. Now we're ready for board responsibilities. I think Darren and I could probably do a whole presentation on just this, or on just fiduciary duty, because these are really.
I'll just say this: we need 1 hour to do this slide, but in the meantime,
exactly.
we'll do it in a minute and a half. So
the important thing to understand is that a board's responsibility to preserve, protect, and maintain does not just pertain to the maintenance and repair responsibilities. It's a much broader field of view for their duty to enforce governing documents, their responsibility to conduct board meetings, their obligation to make good faith decisions for the community, their duty to operate the community association from the financial, legal, and even social standpoint. So all of those are part of the board's responsibilities, and all of that goes into maintaining and enhancing the value of the community. So now we've got our balancing slide. We've got powers and duties. And so Spider-Man, this, every time I see this slide, it always reminds me of Spider-Man. Nope, that one. With great power comes great responsibility. So that's something important that board members need to keep in mind, is that you have an awful lot of responsibilities. I started doing homeowner training orientations, especially, we're back to Darren. I love it. One more back. So, you know, the important thing that I want board members to really take to heart is that, especially in communities with a larger population of newer homeowners, first-time homeowners, or first-time living in a homeowners association homeowners, they will often have really different conceptions about what the board is and isn't for, and their rights and responsibilities. And it always strikes me as an important thing to emphasize that homeowners have a much smaller bucket of rights and responsibilities in the common interest development than the board of directors does. That's by design, by legislative design, by design through all the docs that Darren talked about. So duty, this is a mandatory obligation. It's non-discretionary. The board must do these things like collect assessments, enforce the governing documents, maintain the community. These are things that they must do. A power is a right the board has to exercise or not. So that could be, how much assessments do we want to collect this year? What type of enforcement measures are we going to use to gain compliance? What are the specifics of our maintenance that we're going to undertake? Are we going to do a preventative maintenance program like the rep from All Seasons suggested, or are we going to be reactive and like, whoops, the roof has leaks, it's now time to replace? So just know that powers and duties are exercised together, and you need to be very mindful about that. Now we're on to attitude check. Maybe we should have put this at the beginning of the presentation, but it's wonderful that all of you are volunteers, you're homeowners, you're not being paid for this job. And it's something that I think we could fill a book of war stories on, in terms of like the different types of board members that we've encountered and the different types of boards that we've encountered over the years. And I mean, often you look at someone and say, why are you on the board? And they may say, because I can't get off, because no one will step up and serve. Sometimes I think that's crazy. So you're like, well, for most of us, our home is going to be our largest single, asset and investment in our lives. And we're like happy to let it be operated by, no one who's like willing to serve. And so I always encourage board members to really come and approach being a director with a heart and a thought of service to the community. And sometimes that can help to create an atmosphere in the community where more people may be willing to also serve and facilitate the operation of a community association. Next slide. So Darren's going to talk after this, but the one thing that CAI stresses, and certainly I also stress, and in my personal experiences found applies, that those directors who do come with a heart of service towards their community associations typically have better run, better operated communities. There's higher levels of participation, there's lower levels of community strife, and it just is something to really keep in mind. People get elected for all different reasons or appointed, and just keep in mind that the way you elect to engage with your community members, the way that you elect to engage with your fellow directors and management, especially at the meetings where other homeowners are hearing, they'll often mirror the behavior that they see. And I think it's really important to stress that I encourage professionalism among board members, even though it's your home and sometimes it's easy to be casual about it. This is still the business that has all those legal contracts and documents. And so Darren's going to cover fiduciary duty next. And I just like to leave with that. And now I pass the baton to Darren.
Yes. So, did you know you married the association when you got elected to the board? So, when you become a director, you enter into what's called a confidential relationship in the law. That's what we call it, a confidential relationship with the association. It's the same relationship that folks enter into when they get married, because oddly enough, spouses in a marriage in California are held to the same standard of care as an association director to its association. It's the oddest thing that the family code in California references the corporations code when they're talking about, say, for example, the duty of disclosure. And so when we think about when you became a director, you entered into this confidential relationship with the association and you became a fiduciary. Fiduciary is an old Latin term that basically translated into English means trustee. You are acting for the benefit of others. You hold the property and the money of the corporation at the board's control. And so as a fiduciary, the key thing to remember is that your interests are set aside and the interests of the association become primary. Most of us serve on our boards of directors in our communities because we live there. And we may have a particular goal in mind or idea that we think is good for the community. But fundamentally, that goal or that standard that you intend to apply has to be in the best interest of the association, which is the primary goal of all directors and should be the guiding star for your decision-making throughout your term on the board. And when we think about being a fiduciary, I always like to say it's the highest standard of care that is imported or forced on us by the law. In other words, we are to hold ourselves above, right? We talk about these ideas of being above the fray, professionalism, etc. That's not just a matter of it's nice to do that, it's a matter of the law demands it of us as directors, that we act in the best interest of the whole and that we always put our own interests behind those of the association. So you're in a position of trust and confidence. That's why you're in this confidential relationship. All these words are starting to connect, right? Confidential relationship, a position of trust and confidence. Common interest developments must meet these high standards. How do we meet them? Through honesty, integrity, undivided loyalty, and diligence with respect to how this corporation is governed. And that respect is owed to all members as a group, the whole. As some folks will say, a holistic approach to how we govern. We're thinking about all members. There are times, I always use the example of, the association needs significant repairs to the common area. The association must raise assessments. An individual director may sit there saying, I cannot afford this increase, but fundamentally it is best for the community. And I must vote in favor of it, even though it's against my interest to raise my own assessments to meet this need in the common area, because fundamentally that is what a trustee does. And so you are, as I say, a fiduciary, a trustee, you're in a position of trust and confidence. And as part of that, you have specific duties under the law. So we've talked about duties under your bylaws, powers and duties that are assigned by our governing documents. But then the law also assigns duties to directors who are fiduciaries. And the first duty that you have as a fiduciary is the duty of care. You must perform your duties in a diligent, reasonable way. You attend and participate in board meetings, right? You're reviewing board materials, before you attend the board meeting so that you're prepared and free and able to discuss those matters at the board meeting. You attend the board meeting, which is, you'd think that would be the easy part, but it can be difficult, right? We all have many different competing interests in our lives. But when you're elected to the board, a primary concern is always going to be, I must make these meetings. I must attend them so the business of the association be carried out for the benefit of all members. And so when you're thinking about one of your duties of care is to always act reasonably, to act fairly, to act as a reasonable person would in the same or similar circumstances. It's to attend board meetings, to be prepared for those board meetings, to be prepared to make decisions, and to discuss, deliberate, and decide on matters of association business in the highest level of professional skills and attitude that you can muster. And then fundamentally, one of the oddest things is, as a director, you cannot know everything. It is impossible for you folks as directors to know the answer to every single question you will be presented with. And what that means is you as directors are allowed to ask experts and folks in the field that are able to advise and assist the association, whether that's completing a federal and state income tax return where you're relying on your CPA to prepare those documents. You may look at those and go, I'm not really sure whether those are accurate or not. But so long as you have trust and confidence that your CPA is, in fact, a CPA, is experienced in completing tax returns, the board can rely on those recommendations or those actions by professionals. Same is true for your attorneys or your landscape professionals or your roofing professionals. You as a director can rely on the advice and recommendations of those folks, and that meets your duty of care, meaning we didn't know the answer, so we consulted, and the consultation resulted in a recommendation that we do this. And based on that recommendation, the board followed it and did exactly what was asked. If you're doing these things, you're meeting your duty of care. And it's important to meet the duty of care because it is a standard that you are held to as a director, as a fiduciary. Same is true when you're thinking about the duty of loyalty. And so we think about the duty of care is how you act, how you conduct yourself, how you carry out business. Duty of loyalty kind of sounds the same or similar, right? But it's loyalty to the association, to always be acting in the best interest of the association, and most importantly, to avoid self-dealing and conflicts of interest. And so self-dealing is one of the most difficult ones because, again, you're on the board because you live there. You might receive special benefits as a director. I would encourage you to never receive special benefits as a director. You should always be thinking about the interests of the whole and putting your own interests aside, as we talked about earlier. And the duty of loyalty is one of those things that prohibits and should protect the association against a director either acting for themselves, self-dealing, or conflicts of interest where they create a dilemma, meaning a conflict of interest might be, for example, I do not want to pay assessments. And as a consequence, I am not going to pay assessments to the association. Well, the board has a duty to collect assessments, and when a director chooses not to, that creates a conflict of interest for that director. And the law actually mandates that that director has a statutory conflict such that they cannot participate in the deliberation and decision on how to proceed with that director who is not paying assessments. That is one of those times that there is a clear, absolute conflict of interest that the director cannot participate in. There are many other conflicts of interest that we're not going to go into today, but do remember, if you feel a conflict, you feel that somehow your interests are different from the association, that is a good time to, one, speak to your fellow directors. Generally, that's done in executive session under as a personnel matter, and explain why you believe you have a conflict of interest and can no longer participate. Same is true if the remaining directors feel that a particular director has a conflict. So the duty of loyalty really drives these issues, that to avoid self-dealing, to avoid conflicts of interest. And I would also tell you that the duty of loyalty also means what we often call in this business the one voice rule, that the board speaks with one voice to its membership, that the majority of the board governs. The basis for that one voice rule is the duty of loyalty, that your loyalty is to the association above all else. And you may not have agreed with what the majority did, But your job as a director is not to undermine and destroy the association. It is to accept that the majority position won the day, and maybe at some point in the future, you may be able to convince the majority to follow your position or what you think is right and best. But in the interim, as a director, you cannot damage or destroy the association because you disagree with what the majority did, because arguably that is a breach of the duty of loyalty. That we move to the business judgment rule and the shield that protects you against the sword of the breach of fiduciary duty.
Amen to that. So just understand that meeting the duty of care and the duty of loyalty, so satisfying that you have fulfilled your fiduciary duty, why it's so important to understand what it is and how to meet it as a director is because when you can establish that you've met that standard, the law and the courts defer to the association's board and your presumed expertise. It's called the business judgment rule. It means, all right, when you've established we've met this duty of care and duty of loyalty, the law cares that you engaged in the process, not necessarily that the outcome of your decision is the right outcome or a good outcome. It generally stands to reason if you've engaged in reasonable due diligence and you've had the fidelity to the corporation above your own interests, you're going to have better outcomes to those decisions. But the good news for all directors for volunteer directors, that is, of common interest communities, is that you're not held personally liable for the decisions and for the outcomes. When you can establish you've acted in good faith, that you believe is a reasonable standard to believe with reasonable inquiry, you've met your fiduciary duty, you are entitled to the judicial deference, and you have the business judgment rule at your service. So it's just something to know that you, yes, have a important responsibility to meet, but you also have a helpful liability shield as to your personal interests for the decisions that you make. And so just keep that in mind, that there is a statutory protection for all directors in both the Davis-Sterling and the Corporations Code. So now we're going to press forward to the roles of officers. Like I've explained already, officers are the task doers appointed by the board. Look to your bylaws to find out who those officers can be. So president, they are not the kings or queens of the association. It's also not the popularity contest. These are the folks who are the leaders of the corporation. And one of their most important responsibilities, chairing the meetings. Please pick a president who is comfortable actively chairing the meeting and running it in an efficient manner. The president will typically serve as the liaison between management, legal counsel, and other vendors. Not always. The board could chop that up, but typically it would fall on the president. And then they also help to finalize the agenda. Little quick note, all board members can put things on the agenda. It's not only the president's ability to do that, but they do set and finalize it. Next, the vice president. This is not just the person who's waiting for the president not to be there. It is actually an important role. And one of the reasons is, you could have a president who's out of town. The vice president steps in. They may sign contracts in the interim. They may sign checks. They may liaise with the management. So it is important to have a president that has a good rapport with your vice president, and also a vice president with the vendors, because they do certainly step in. The secretary of the corporation, it looks like the, longest list of things, but these are the official record keepers of the corporation. Typically, that means they oversee the management company, who is often the custodian of records. They take the minutes, or they oversee the taking of the minutes. In terms of minutes, best practice, we don't make them little transcripts of what was said by who in the tit for tat. Put the corporate or actions, a motion that's made. It doesn't matter if it was not seconded and passed, you still put the motion that was made in the record, and that's an important thing. And then, of course, the secretary signs the minutes. Important to note that the secretary signs the minutes when the board approves them. So it's not the secretary says, oh, I wasn't at that meeting, I can't sign those minutes. You're like, sure you can. The board approved them, you sign them. So I always like to point that out. Next, we've got the treasurer, the chief financial officer, CFO. This is not the person who's forced to prepare the financials. Typically, they'll oversee it. It is also not the only person who's responsible to look at and review the financials. The Davis-Sterling Act imposes that obligation on all board members. Every single month, open those financials, look at them. But the treasurer is going to be the one who liaises with management, if you have it, or with your, accountant or bookkeeper to, address any questions. They're typically going to be people who are more comfortable with numbers. So not folks like Darren and I who can't add our ways out of paper bags, and that's okay. We have other many good skills. And then at-large members. It is important they are board members. So sometimes they're like, oh, I'm an at-large member. You're like, are you a board member? Yeah, you're a board member. You're voting on stuff. So it is not an unimportant role because remember, the directors are the ones who vote. Officers are people who have tasks that they do.
And officers never vote. And so there are many people that think, oh, the president only votes when there's a tie. And I will always tell you, the president never votes. Only directors vote. Officers, as Jasmine say, carry out tasks.
Yes. And then committees, because I know we are running short. So committees, they're appointed by the board. A couple important things. So you've got standing committees. Those will be ones that are specifically like authorized and created in your GovDocs. Normally going to be your architectural committee, sometimes a finance committee. We've got executive committees. These are lawful. I literally had this question come up last night in a board meeting. Executive committees can only include board members. They can sometimes be created for litigation or legal purposes. Sometimes
conflicts of interest.
Sure, conflicts of interest. And sometimes there's friction with maybe a rogue director. So executive committees can be created for those purposes. And then we've got ad hoc committees. Those are specific project purposes. They may have limited duration in terms of what they're for, researching an issue, interviewing, new vendor, you name it. So those are specific purpose entities. One thing I generally recommend a committee charter. It's not required by the Davis-Sterling Act, but it can be helpful to set the board's expectations of the committee and any limits of authority. Normally, committees don't have rights to approve things. That's something that needs to be approved by the board. So it's helpful to make sure that the committee understands what they are and aren't entitled to do. And with that, Darren's going to take it to rules.
Yes, so rules and regulations, adoption and enforcement. When we're thinking about rules, the thing to remember, as we said earlier, is most of our governing documents require a vote of the membership. But rules, like we said earlier, are unique in that they're passed by the board, amended by the board, or revoked by the board. And so the board has authority to adopt rules under your governing documents. They have to be in writing in order to be effective. I don't know why we have to say that in the law, but it seems to make sense that we have to tell folks, in order to have a rule, you must write it down. Why is that important? Because folks need to know what the rule is. You cannot have an underground rule that is enforceable that nobody knows exists. That is not fair, that is not reasonable, and arguably a breach of fiduciary duty.
I mean, we can't do it from our mind, Darren.
No, we cannot. We cannot say, didn't you know? You're only supposed to park on the street for 2 days in a row. Everybody else knew except for you. So rules are always in writing. And then fundamentally, we cannot contradict or try to amend our other governing documents through the rule process. Now, I'll say there is a unique exception in that regard, and that is election rules. Election rules are driven by the law. In other words, it doesn't matter what your governing documents say. It matters what the law says. And so your election rules must be in conformity with the law. So it's another one of those times where the law supersedes what your governing documents say. But for the typical rule that the board is adopting, always remember they must be consistent with the requirements of the governing documents for the association. Another thing to remember is we can't adopt a rule for everything. And there are times that we're not going to be able to have a rule for every single issue that comes up, no matter how much we would like that. But do keep in mind that you may have some gaps in your rules that perhaps the board may need to fill. Rules and regulations that are required by law, like we talked about earlier, election rules are required by law. We must have them. It says that in the civil code. And if we fail to adopt them, there's an argument that we have violated the law. We're also required, in addition to election rules, to have an assessment collection policy or assessment collection rule, because really that's what it is. It's not just a policy. It's not just a nice idea. It's a rule that we're going to live by, and it must be in writing, and it is required by law. Now, on internal alternative dispute resolution policies, internal and alternative, boy, say that 4 times fast. Internal and alternative dispute resolution policies. When you're thinking about these, there's actually not a mandate that you have them. You do have to disclose them. And the nice thing is that the law has filled that gap for your association. They have default standards that the association can use and disclose to its membership as its dispute resolution policies. Again, rules that we follow. And then, of course, architectural modification. If your community does architectural review, generally speaking, you're going to want to have a process, an application process for that review so that members can understand how on earth do I go about changing something at my home. So rules can be required by law. Rules can also be discretionary, like that rule we talked about earlier involving somebody parking on the street or on their driveway. So other rules that we can adopt, and a key one, if you have, say, for example, a common area pool, you're probably going to want to adopt rules with regard to that pool to ensure its safe use and fair use by the residents. Perhaps you have a clubhouse and you want to adopt rules as to how that will be used. Perhaps you want to adopt rules as to how meetings will be conducted, how parking is going to be resolved, as we discussed earlier. And then, of course, there can be a whole host of other things that you may want to adopt rules on. How cars are stored, where cars are stored, all manner of things. But fundamentally, always be thinking about, what do our governing documents permit? Is this within the scope and authority? How are we going to write this out? How are we going to make it right? And so when we think about those rules and regulations, oftentimes folks want to write very detailed, very specific rules. That can be helpful, but at the same time, if you get so detailed, it may not fit all of the circumstances that may arise. And so when you're trying to write the rule, you're generally trying to balance between specificity and broadness so that the rule has fair and equal application. And hopefully, meets the association's need throughout the life of the development. Focus on that member. I'm not really sure if I agree with that, but we are focusing on issues that the association is routinely having to address, and sometimes clarifying the obligations of the owners, residents, etc., to the association can be very helpful. Avoid the heavy-handed rule. Avoid being the bully of the neighborhood. The board's role is to govern in a fair and reasonable manner. That's part of your fiduciary obligation as a trustee. So heavy-handedness is not necessarily your friend. However, there can be times, for example, if there's some sort of significant safety risk. I have many communities that exist within high fire zones, and in those areas, maybe the rules are some folks may see them as more heavy-handed. But I would say when safety issues are on the line and people's lives are dependent upon those rules, maybe, just maybe in those circumstances, a more viable rule is a heavier rule that has more impact and effect. Also remember, do not discriminate. We say target children here. I say target families. Do not do this. Do not target children for special treatment. Children have a right to play in our communities, and the law is quite clear about that. I know that no one wants to see harm to children. As a father, I do not want to see harm to my children, but I also must recognize that there is this balancing act. And so when we're adopting rules, we want to make them non-discriminatory so that we do not treat certain people one way and other people a different way. There's that old book that spoke about some are more equal than others. That is not a good way to govern your community. All of us should be treated fairly. All of us should be treated professionally and reasonably. And passing rules on a sharply split votes, it is what it is. The majority of the board makes the decision ultimately, and the majority of the board controls the day. And like we talked about before, the duty of loyalty asks us, please, even though your position may not have won today, please support the board, please support the association, because fundamentally we need a unified voice when we're speaking to our membership. Key things to do when you're adopting rules. Explain why the rule is needed. It's helpful to tell the members, why on earth are we adopting this rule? Sometimes transparency is your friend. I would say more often than not, transparency is your friend. And explaining this rule is necessary because this issue has emerged, this issue has arrived. Think about the future members. How is that going to affect the current members and future members? And not making it so specific that we're targeting some specific member or specific group. Emphasize that we're trying to clarify for neighborly conduct. You know, I joke that, you know, the rule, why do we have to tell people that rules have to be in writing? Well, because unfortunately, we oftentimes have to explain those things. And so oftentimes we're adopting rules to clarify what should be common sense, but here we are. And then, of course, always trying to listen to our fellow directors and your experts is how to improve our rules. When we're adopting rules, this process requires, again, the rules to be in writing. That has to be within the authority of the board. It cannot conflict with your governing documents, including your CC&Rs. And then ultimately, we adopt these in good faith, complying with the requirements of the law for a rule change. And then at the baseline, these rules must be reasonable. When you're adopting rules, if the rules relate to, they can relate to the use of the common area, they can relate to the separate interest, that means either the lot or a condominium. They can involve disciplinary hearings. What is the disciplinary process that we're going to follow, etc. The board must provide written notice of these rule changes. So do keep in mind that we can't just adopt a rule secretly. It has to be done at a meeting that is open to the membership, that members can come and provide comments on the rule prior to the board voting to adopt it. And we're required by law to give our membership general notice that we're intending to adopt the rule at least 28 days prior to the meeting where the decision will be made after hearing written or member comments, whether written or verbal at the meeting. And so do keep in mind, there is this institutional or statutory transparency that was created back in 2004, saying that whenever the board adopts the rules, it must follow this process. Publish the draft rule with a purpose and effect statement as to what was the purpose of these rules, what will be the effect of these rules. We publish that for at least 28 days to the membership. And then following that, we hold an open board meeting where we hear member comments. And following hearing member comments, the board votes on whether or not to adopt those rules. And then, of course, part of the transparency process is once we adopt the rules, within 15 days of adoption, we're telling the members just plainly, we have adopted those rules. And that is an important aspect of what we do because members need to know, even though they may not care, but they need to know that those new rules were adopted. Also keep in mind, rules can be reversed by a vote of the membership. So if the membership say, gosh, that rule was great, but we don't really like it, 5% of your members can petition to conduct a vote of the membership to reverse a rule. And it's a majority of a quorum of the members that may reverse a rule. And once reversed, that rule cannot be readopted by the board for at least 1 year. And so while this doesn't happen very often, there is a safety valve if a rule is overburdensome or if a group of members votes to overturn it. Please consult with your attorney if that ever happens.
All righty.
Wrap up quickly because we're running low. Moving
All
on
right.
to enforcement.
Enforcement. So, important concept before HOAs, before the board decides to go legal, we recommend that the association have a equitable enforcement policy. And I mean, I think it's important because the objective of enforcement should be compliance, not punishment. I know sometimes we'd like for it to be a whole lot of punishment because we've got those members. We all know in every community who they are. So, you know, just consider having an enforcement policy and a fine schedule. I recommend every community have them. It sets the process that your membership can anticipate if violations do occur, and it helps put everybody on equal footing. So now once we're at the, you know, first step of an enforcement process, sometimes I recommend a progressive discipline. I mean, certainly it's not necessarily always required to be that way and could change depend on the severity or seriousness of an issue. But I think a lot of times in community associations, and for good reason, management companies will have policies that say, hey, we have to document things in writing. So it's not to upend that, but sometimes I think a good call conversation can go a long way, and it's something I really do encourage. I have to remind myself to engage in that same concept. Call the opposing counsel, return the homeowner's phone call instead of just, I'm only communicating with you in writing. One of the important things that I do encourage is that context matters. And so you can have a new homeowner and they get a bunch of violation notices, and it's like, notice of violation, what kind of an affront that may seem. Or like, I haven't even had time to read the governing documents. I just bought my house. I'm sorry. I didn't know we couldn't have contractors on a Saturday. My bad. And so the words that you use even for an enforcement process can really matter. I suggest having softer language that may seem, kind of like limp-wristed, but it's intended to try and achieve the objective, which is compliance instead of punishment. So framing letters to a homeowner as a, neighborhood alert or a neighborhood reminder or a, courtesy notice, it sounds a lot friendlier and more neighborly than notice of violation, where, oh, I didn't know the trash cans were out again. So just it's something that I recommend. Now we go into the enforcement procedures. We've got a couple different ones. We've got internal dispute resolution, IDR. What it is a conversation. If a homeowner asks for IDR, it is a requirement that the association accept that request and they have that conversation. So what does it mean? Well, the board gets to designate a director, meaning one. It's not the whole board who gets to come, although I guess if the homeowner were amenable to it, you'd need to notice it as a board meeting. And that's why the legislature has designated it as a single director. They get a phone a friend, so you can have a second director there, a community manager, legal counsel, and so can the owner. So it really is intended to be a distilled dialogue. Sometimes you may want more structure to the meeting so that it can be a productive discussion. But the objective is, what are you trying to accomplish? What is the dispute? What would it take to resolve it? And the director who attends, they would still have to take back any type of, yeah, we could agree to that, no, and couldn't agree to that. You have to take that back to the board of directors, and ultimately they will approve or reject the offer. So now we've got alternative dispute resolution, ADR. Typically, it's a non-binding mediation, but it's really any dispute resolution proceeding that's with a third-party neutral. And so I love mediations. I think they are a really effective forum. And so I don't view them as a negative when a homeowner has requested one. I certainly do recommend that they tender the issue to insurance at that point, because ADR is a formal legal process in connection with HOAs, and it can often be a triggering issue under your DNO or your insurance policies for future coverage. And so next we've got arbitration. It's in a surprising number of contracts. So the association may be subject to arbitration for contractor disputes and the like. Sometimes homeowners will say, I want arbitration. It's often a misunderstood term. So just know arbitration is a private proceeding that the parties pay for. It's typically overseen by a judge, but doesn't have to be. It calls for an expedited process in terms of like less number of depositions, smaller amount of discovery, typically less witnesses and days of the proceeding. But it can be expensive because you're forking out money every day for the judge. They typically will charge, but like $5,000 to $10,000 a day for their services. So I will always ask a homeowner when they ask for arbitration, you sure about that? And typically they're like, let me roll that back. I meant mediation. And then litigation, it is a proceeding that is wound its way through the court system. Ask any attorney who does HOA law. This is and should be seen as an option of last resort. Sometimes it's necessary. And typically, if a claim is filed against the association, you would always be well served tendering it to your insurance carriers, and they may or may not cover it and assign defense counsel. So now we've got the hearing process very quickly. The most important thing is that your hearing notice has to be in strict compliance with what the law requires. It needs to have date, time, location of where is the hearing going to be held. It needs to list the specific provisions in the governing documents that have been violated, saying something like you're not allowed to have unauthorized architectural modifications. Well, is that Article 12 of the CC&Rs? Is that Section 16 of the architectural standards? Maybe it's both, but you need to actually list the things in the governing documents that were violated. Also, you need to specifically identify the types of disciplinary enforcement measures that may be considered. Are you going to impose a reimbursement assessment? If so, specify the amount of it. Are you going to impose fines? If so, specify the amount of it, as in like the base level. And if you're considering continuing fines, the process of what that would look like, so that there is clear and transparent due process to the homeowner. If you don't get it right, you sort of start again and have to do the process over. So it's really, really important to make sure that your hearing notice letters are in compliance with the law. And then you have to send a results letter within 15 days of the hearing itself. All right, so now we're on internal dispute resolution. I've covered most of this. One thing that I recommend, as Darren said, the law has a default IDR policy, and that's great. I recommend my clients adopt one that is not only in compliance with the law, but has some additional bells and whistles, things like addressing when counsel attends the meeting, so that the homeowner is on notice, hey, I can't just spring my attorney on the association without giving them the opportunity to coordinate their attorney attending this meeting as well. Maybe facilitating an IDR between warring homeowners. Addressing repetitive IDR requests. I have homeowners and HOAs who are like, every time they're upset, I want an IDR. And they know that associations have to accept requests for IDRs. So it's to try and not winnow down a homeowner's right to exercise this, but it's to say, look, you need to address all of your issues that you have at one time, not in successive subsequent IDR requests. And then last but not least, we've got this wonderful dispute resolution flow chart. Warning letters, they're important. Like I've said, I suggest calling them something other than warning letters so that it is a softer approach that may result in compliance. We've got your hearings and IDR processes. This is really the part where you're trying to get compliance when wheels fall off the bus. We've got alternative dispute resolution and litigation processes. They can be emotionally draining, so we really recommend that you try to resolve the disputes at the warning or the hearing enforcement stages, rather than having it get down to litigation and elsewhere. And with that, we were a little over. Thank you guys so much for your time and attention. Back to you, Rachel.
Hi guys. All right. So I have recorded all of the questions in the chat. Since we are speaking with you for our next session, I am going to have everybody take 5 minutes. 5 minutes. We'll take 5 minutes, come back here at 10:15, and then we will start doing all of the questions. The questions that came in first will be answered first, etc. So if you want to start typing your questions into the Q&A or the chat, go ahead and do that while we're on a break. Thank you guys. That was a lot. That was a lot.
Yes. Next time we're going to stop at rules. So
yeah, that might be good.
We're getting there. We did it.
You did it. That was great. Thanks, guys. Feel free to take a break, and we'll be back in 5 minutes.
See you just a moment.
Bye, guys. Thank you to Education Committee member Miranda Ward on the back end, who is fielding the questions to make sure they're not too specific. Always helpful. This is now the Ask the Attorney portion of our time together. Oh, I need to let you unmute, huh?
I'm just going to do something real quick with a share screen before we start, if that's okay.
Yeah.
Yeah, perfect. So here we go. Just remember, folks.
Oh, okay.
The information in this presentation is prepared for general informational purposes, should not be construed as legal advice on any subject matter to answer specific legal questions or problems you may have. Do remember, we're going to try to ensure our accuracy, but we cannot guarantee our accuracy, and we may make mistakes because we're working within a few moments. The law is constantly changing, will always vary by circumstance. Therefore, information on a legal issue may not be current or apply to your specific situation. You should not act or refrain from acting upon the information without seeking the advice of legal counsel. And then viewing any of this information today does not create an attorney-client relationship. So we just want to make sure that's clear for everybody. And there may be questions that are so specific that we really shouldn't answer. And we'd ask you to please speak with your counsel for your association on those matters before making a decision.
Thank you, Darren. That was great. And we are recording your questions as they go into the chat and into the Q&A. But our first question from today is, if the bylaws allow an HOA to increase the number of its board members with a majority consensus from its HOA members, can a board president delay the upcoming election by insisting that a vote be held to increase the number of board members before a board of director election can be held?
Maybe. No, I would say no. The board determines when elections start and finish. And so that's actually, the president can encourage a delay, but fundamentally the board of directors must make the decision because they're the governing body of the corporation. The president's day-to-day operational issues. Yes, when will the board sets the date, when will the election start? And from there, the president might work with the inspector of elections to carry that out. But generally speaking, the board president does not have any more power than any other director in terms of when is that election going to start or stop. But again, review with your counsel and make sure that that is consistent with what your governing documents provide for.
Now, it is an important tidbit to know that the board could vote. They have under the Corporations Code the ability to conduct an annual meeting up to 15 months past the last annual meeting. So sometimes it could be that mathematically they would be able to do a vote to change the bylaws before, but like Darren said, it wouldn't be the president who gets to make that determination. It would be the board.
Great, thank you guys. What is the difference between an HOA and a condo?
Nothing.
A condo is a type of HOA.
And an HOA, I always just say this, HOAs are not defined in the law.
Correct.
Lo and behold, that is a term that the Davis-Sterling Common Interest Development Act never uses. That is a colloquial that you and I use when we're walking around talking about HOAs and homeowners associations, but the law does not speak to it. So condo is a type of association, type of common interest development. As Jasmine spoke at the beginning, condominium is one type. A plan, and the condominium is where you own the airspace. I actually work in a condominium. So my firm, I own the wall and everything inside of it. So that painted surface behind me, I get to paint it. But the exterior wall on the outside is operated by my association. And then I own that outside wall in equal shares with all the other condominium owners. And so a condominium is just a type of association or a type of homeowners association.
Great, thank you. Please clarify, all directors of a board can vote as directors, but not because of their role as an officer on the board, such as the offices of president, secretary, etc.
Okay, so like I said, officers are task doers, so they fulfill roles and functions of specific types. It's the board members and only the board members who are voting. So let's say you've got a board of 5, you've got your president, vice president, secretary, treasurer, and at large. Great. None of those officers are voting on any given issue. It's the board members. And so sometimes there is a misconception that the president is not entitled to vote unless there's like a tie. But the president, like all directors, but president is an officer role, not a board member. All board members have a right to vote on all board motions, period, full stop. So it's just important to understand that board members are the ones who are voting. They are the fiduciaries.
And so when you vote as a director, you never vote as an officer.
Okay, got it. Thank you very much. Well, I don't know what the statement was. Sorry, I should have recorded it. But just curious, in the statement that you stated, there is a law that children have the right to play. Where would I find that law or statute?
Ah,
Government Code Section 12955.
state and federal law under, you know, the Federal Fair Housing Act and the California
Fair Employment and Housing Act.
Fair Employment and Housing
Don't
Act.
forget, there's also the UNRU Act.
This is true.
And so we're talking about 3 levels of regulation on that is specific. Do not discriminate against a person because of their familial status. So the Fair Housing Act, it's a federal law created a long time ago, 1968, that says do not discriminate against people. Seems like we wouldn't need a law for that, but we do. And part of that is do not discriminate against persons because of their familial status. Then California adopts this thing called the UNRU Act. You cannot discriminate against persons because of some unique characteristic or aspect. Being a child is a unique characteristic or aspect. Families are not to be prohibited. We're not to, under the law, create an age-restricted community without applying the principles of Civil Code Section 51.3. And so when we think about it, the reason we cannot discriminate against persons with children is because we cannot discriminate for familial status, meaning they have kids, they're married, whatever it happens to be. And saying to a family, your children cannot play in our community is unreasonable and unfair because children have a fundamental right to play.
Mm-hmm.
It seems reasonable to me, and as a kid, I used to play all the time. I really enjoyed it. And I kind of think we lose track of that as adults and forget that kids do need time to play and be kids.
And this applies not only in the common areas, especially in condominiums, it also applies in their homes.
Correct.
And, you know, a lot of times Darren and I'll field issues and complaints like, oh, the upstairs, the kids running around wild and it's ruined my quiet enjoyment. And, you know, they're acting unreasonably. And boards need to be very, very careful in those situations that we have to balance, you know, what may have been a, you know, prior occupant upstairs that was quiet as a mouse and worked graveyard hours and you just never heard them, and say, all right, we're going to evaluate not based on what this homeowner feels is unreasonable, but if you're engaging in like normal kid stuff, you know, you're chasing the dog or you're, you know, playing with toys, it's probably not going to rise to the level of being an unreasonable noise nuisance. So really engage counsel when you've got these types of disputes in a community.
Correct.
Got it.
And if you're in an age-restricted community, it's a whole different ballgame.
I was thinking that. Anyway, okay. AB 1572 applies to all HOAs. Where can an association learn of the new bills? Is this issue being followed by CAI? And we did, thank you, Miranda, for the link to the new bills. That was posted to the chat. So if you need that, but is this issue being followed by CAI? Darren and Jasmine are both on the California Legislative Action Committee, so I'm going to let them speak to that.
Yes.
Where can you go find the, you know, bills?
Let's talk about what this bill is first, right? What is AB 1572? It deals with applying water.
The non-functional turf bill.
Right? So it's turf that is ornamental or pretty. It's not used for a particular function like an athletic field. I'm trying to think of some other examples of useful turf, golf course.
Designated picnic area.
Yeah, maybe a picnic area.
It could have like trees, like if it's a, you know, little curb area, but there's trees in it. Trees are allowed to be irrigated. Those are useful functions.
Correct. And if you have recycled water in your community, you don't have to worry about this law. So there are some communities in the state that use recycled water to water landscape. In those circumstances, this law would not apply to them. Now, remember, too, this law doesn't go into effect until January 1st of 2029.
So we've got 5 years for homeowners associations to, number one, evaluate whether they have any common areas. This is for common areas that have non-functional turf. Ask your friendly landscape company. They will know what non-functional turf is. They went through it 2 years ago when the governor declared an emergency drought declaration. Then once you know if you've got non-functional turf, you can evaluate the costs that it may take to turn your potable irrigation system into a non-potable one, like from recycled water that Darren was talking about. Or you could say, well, we're going to convert the ornamental grass into drought tolerant or native plant and landscape. So you're going to have to evaluate what those costs will be. We're giving you 5 years notice to start talking about it, understanding what it's going to cost, and then saving the funds, because we know associations are sometimes quite reactive, and they'll come to 2028 and be like, holy Moses, we have to do a special emergency assessment because we have to comply with laws. And it's a lot of times easier to just be the country mouse and like squirrel your little food away along the way so that you don't have to do special assessments if that may apply to your community.
That is the whole point of this. Now, I know there's also regulation that California Water Board is looking at. CAI, through its legislative action committee, is trying to track all of this. We are working on these issues so we have an understanding of what's going on and can help shape and influence on a state level. But it is important for boards to be sitting down, as Jasmine said. Let's think about where is this ornamental turf, this turf that does not provide a function, and start planning and developing a plan for how are we going to budget and replace this at some point in the future. Fingers crossed you get it done before 2029.
Thank you both for that answer, because you've given me the opportunity to plug a couple of things really quickly. CAI is an educational entity first. We have lists of business partners for friendly landscapers. If you need that, all you have to do is email me and I will send you an Excel list of business partner members who invest in your continuing education. And speaking of CLAC, Advocacy Week is coming up in April, so I have included the link for that. The chapter actually is going to be putting out a couple of scholarships for homeowner leaders and managers to attend that on our dime for your education. So please look at that event, see if you're interested in going, and then keep an eye out on your email for that scholarship.
Perfect.
Right. And one other thing, we are, for the first time since the pandemic, we are having, in connection with Advocacy Week, our fabulous Corks for Clack event. It'll be at the Sheraton on, Rachel knows the day better than I do.
Wednesday, April 3rd. So Advocacy Week is April 2nd to the 4th. It's a Tuesday to a Thursday, so midweek. And then that very midweek, we will be doing a wine tasting event in conjunction. So you go visit with legislators all day, and then you come at the end and have some heavy hors d'oeuvres and some wine tasting and talk to your peers about what you learned that day. So
Socialize, right?
Socialize.
It'll be a fun time.
And just an important thing for our homeowner volunteer leaders who we're talking to on this presentation, you and your participation really does matter. CLAC and CAI had a really excellent legislative year last year in terms of, we got the vote for, electronic meetings. You don't have to have hybrid meetings now and other things, in part because we have such an engaged constituency. And, Darren and I, we can go, we're the attorneys. Legislators don't necessarily listen as carefully to us, except when we're talking to our own legislators, but they really do listen to you, their direct constituents. So I can't express enough how important your participation in these events is.
Thank you. This next question is related to AB 1572. Does anyone know where we are going to get the non-potable water from?
You're not, unless it's established. It's generally non-potable water for use in landscape is generally provided by a water utility. And so if you don't have a utility that's able to provide non-potable water, it's, if you're familiar with it, they always call it the purple valves. So they usually use a purple colored pipe designation, purple colored sprinkler designation that denotes it as being recycled water or non-potable water. Generally speaking, your local utility has to be able to provide that. And that's where it boils down to. Not many communities have that benefit. It generally has to be part of the initial plan of the overall development that will occur. or the local utility provides that service. But unfortunately, it's not just something that is available to everyone.
Got it. Okay, thank you. What steps should a board take when confronted with one or two rogue board members stirring up strife within the community, specifically against other board members? What protection do the targeted board members have from public displays of persecution and bad faith behavior?
So it's going well in that community.
It's doing great.
Kidding, I'm kidding. So, you know, one of the things that I talked about in terms of professionalism, protecting the alleged rogue directors, but also the community at large, I recommend that a discussion in an executive session meeting under the agenda topic of personnel. Board members to me are personnel of the corporation, even if they're non-compensated, they're the deciders of the HOA. And I would encourage a conversation first. Sometimes getting called to the carpet amongst all of the board is unproductive. So the board may say, hey, we want to designate, you know, the president or some specific director to have a dialogue. You know, Darren, what are your thoughts?
Yeah, I would agree. Sometimes, you know, I'm sure this happens to Jasmine as much as it happens to me. Sometimes we step in and conduct what's called like a board orientation.
Yeah.
Where we're trying to reorient the board towards a positive working relationship and reminding everybody we can all have a different opinion. And lo and behold, we can all be right. Right? We can all disagree all day, but we don't want to be disagreeable. And so when we sit there and we're talking as a board, fundamentally, it is not about personal attacks. It shouldn't be about personal attacks. We should try to be above that fray. But the problem is a lot of times you're asking folks to say, you know, put your emotion or your feeling aside and let's try to get to the right place. And sometimes having a third party there who's not intimately involved with the board on a regular basis can kind of bring some stability back to the board and remind everyone, you know, we can all disagree about what we think is right. But at the end of the day, the majority of the board will make the decision. And once that decision is made, as fiduciaries, we have an obligation to support that decision. It doesn't have to be active support, meaning I don't have to go out and say, I'm going to take the laboring oar on this thing I thought was a rotten idea to begin with. It really means that you're not going to undermine or destroy the community because your position didn't win that day. And it is one of the big breakdowns in American society. I'll just speak on a larger level, is that people see that conflict isn't just about the idea, it's about your personality. And I'm a big supporter of boards moving from being a personality-based governance model to a policy-based governance model. It is not about us individually, it is about us as the whole, about us trying to do what is best for the community. And unlike elected officials, you folks are held to a higher standard of care. Elected officials are not fiduciaries to you or I or anyone else. But when you're serving on a board of directors, you are held to this high standard of care. You are held to a duty of loyalty to the corporation above all else, including your own personal desires. And so that's where meeting sometimes with a third party, like I say, either maybe the manager's supervisor comes in to try and act as a mediator to try and settle those issues that maybe somebody said something that offended somebody else, or bringing in Jasmine or myself to meet with the board to do a board orientation type program where we're resetting how this community governs and trying to work together in a positive light. But it also takes some humility, right? We're taking off our hat and going to them and saying, fundamentally, we cannot continue to operate in this manner. We are damaging our shared interest of the association is being damaged on a daily basis. And there's got to be a way that we can work together. We may not agree about everything or anything, but we do have to work together and try to not destroy the community with each statement that we make.
Thank you, guys. Are HOAs exempt from the Corporate Transparency Act?
Yes. That's the short answer, yes.
Oh, I disagree.
Transparency Act, what the heck is that? The Corporate Transparency Act is a federal law to avoid fraud, right? So we're talking about people that are stealing money, drug dealers, maybe something like that, or I'm operating some black market business that's not lawful. The Corporate Transparency Act is designed to flesh out those corporations that may be committing crimes under the guise of being a corporation. I think the general consensus, correct me if I'm wrong, Jasmine, is that most attorneys are concluding that associations are subject to this law and must register its directors beginning in January of 2025.
Correct.
And
So
so please talk to your attorneys. This is an important one because there are monetary penalties for not complying.
yes. So, and just a little heads up, like Darren said, the reporting compliance is January 1 next year. CAI on the national level is trying to work on obtaining an exemption for common interest communities. You know, stay tuned for that. But starting around the summer, if we haven't obtained that exemption, it would definitely be appropriate time to start meeting with legal counsel to understand what are the reporting requirements.
Correct. And it will be a hassle, but once you do it a few times, I don't see it as much different than our registries that we do every other year with the California Secretary of State in terms of, you know, it's just another step in the governance process.
Thank you. We had received some questions regarding elections from our Wednesday program that Jeff Brown gently was like, save that. So if the initial quorum requirement is not met in a board of directors election, can a majority of the HOA members who are present at the meeting decide to cancel the board of directors election instead of rescheduling?
They could adjourn the meeting, right? So what are we talking about? A director election? Where is it concluding? A member meeting. The members are the quorum that is required to be present. If you don't have a quorum of the members present, either by ballot or physically present at the meeting, you do not have a quorum. The only action that can generally be taken when you don't have a quorum is adjournment of the meeting. When you adjourn the meeting, generally you should be setting a new date for an additional member meeting to reconvene, but you don't have to. And so the members could arguably say, we're going to vote to adjourn, and that ends the meeting.
It could be that the members who are, present at that meeting determine we're not adjourning the meeting. And if that were the case, the meeting would effectively not be held.
Mm-hmm. Yeah. So it's an odd situation, but there we are. The members control when their meetings are, or when their meeting is adjourned, and control whether or not it's going to be rescheduled. And so, you know, first is, of course, you always have to determine the quorum, and then from there, decisions are made. And arguably, I guess the members could say, we're just going to adjourn. We're going home. We're done. And the election would end. Under most governing documents, those directors that were previously elected would continue to serve until their replacements are elected. And so, you know, the board could always say, hey, we're going to redo the election, or we're going to reschedule the adjourned meeting. I don't know. You'd have to, the members will control that, but they can arguably do that.
Thank you, guys. Another question in regards to elections in California: how often are board of director elections required to be held, and what can an HOA member do if a board member wants to remain on the board indefinitely for more than 3 years?
The minimum number of elections must be held at least every 4 years. Then your governing documents have some other clause, most likely. So looking to the bylaws. And the bylaws usually set out the frequency of director elections, the frequency of member meetings. And so member meetings are required at least once a year, as Jasmine said earlier. And so we should be doing that every year, or at least trying to hold a member meeting.
Now, it could be that you're not necessarily electing directors at that meeting because they've already been approved by acclamation, or just the schedule of the director election frequency is not occurring. But director election is like one aspect of a member meeting. A member meeting is just sometimes that it has to be held, and it can be a discussion point for the homeowners. Who knows?
Yes. And then removing a director, I'll just jokingly say, that's why we have elections. If somebody wants to be on the board forever, they have to be elected by the membership to the board forever. I suppose there could be a situation where members are refusing to vote. You didn't hold an election where that director might continue to serve year over year. But elections are the important correcting mechanism for ensuring that those that serve on the board are chosen by its membership. And if the members elect this person over and over again, that's their choice. I'm a firm believer that people should be allowed to elect their representatives and should have that right.
On that note, an important thing that was just implemented in the law this year is that we now have a 20% reduced quorum that applies to election of directors. And so if you had an association governing documents that didn't have a lowered adjourned quorum, for instance, now there's a statutory adjourned quorum of 20%. There's some processes that those communities would need to adhere to in terms of the notice of the adjournment and whatnot. But just know that there is a helpful little, adjourned safety valve, if you will, for lowered quorums to hopefully allow for more director elections to move forward.
Yeah.
Wonderful. Thank you. I have one more question. Starting on 1/1/24, are all Board of Directors elections required to take place in person? And does this mean the inspectors of election must appear at the meeting location in person and cannot join the meeting remotely?
I'm going to tell everybody on this call, Jasmine and I are going to leave that to your attorney.
Okay.
Please consult with your attorney regarding whether or not the inspector of elections can appear remotely by video.
I think there's probably some differences of opinions, not necessarily between
Certainly.
Jared and I, but I'm not stepping in that one. I'm glad you said it that way.
Yeah, talk to your attorney, follow the advice of your counsel. Or if you don't want to talk to your attorney, at least talk to your inspector of elections, see what they feel comfortable with. But I'd suggest talking to your attorney, because that will give the board a safe harbor that we're following the advice of counsel.
We got one more question. One second. Miranda, I'm sorry, I'm not going to give you time to edit this one. You mentioned that owners of title on property is the members then in the HOA. And if a person is not listed on that title, that the person is not an HOA member. Thus, is that person not on the title, not entitled to amenities and services of the HOA?
Answer with it depends.
Yeah, I was going to say it's a little bit more nuanced than that. So that non-listed individual, they are not entitled to exercise the right. So meaning they cannot vote. Although if they were a power of attorney, then they could vote. They wouldn't be allowed to run for the board of directors, because only members, meaning the record title owners, are entitled to run for the board of directors. So those are the certain rights of membership that could only be exercised by the record title holder and not necessarily an unnamed spouse.
Correct. And do check your bylaws, because some bylaws do allow non-members to serve on the board of directors. So always remember, check your governing documents on that issue. But it is about the rights and privileges of membership, which sound really important, but it's not that many, right? Serving on the board of directors, it's being a candidate in director elections, voting in association matters. But the other person is a resident, so they'd still have rights to use the common area facilities, the pools, the clubhouses if we have them, and receive those benefits as a resident.
Wonderful. I think this is the first time that this has ever happened with this course where we do not have any more questions. And I get to ask you.
Call.
Yeah, we'll do a last call. But I would like to ask you too. We've gone through insurance, we've gone through reserves, we've gone through finances, community managers, board meetings, and now law. Any other advice as we head into this year?
Have a great year. It's 2024. It's a good year, interesting year. So the key thing I just say is, remember, we're governing people, and there are a lot of folks that live in our community with all different life experiences, in different positions, and fundamentally trying to be fair with our membership at all times can be difficult, but it is the best practice. I kind of feel like I'm preaching to the choir, because those that show up to these type of events are trying to do the best that they can for their community and are trying to be that well-rounded director that makes good decisions. What I'd say is just continue to do what you're doing. Seek out education, seek out opportunities, and take those opportunities and that education and that civility back to your community. and set the standard. As I always joke, you know, in my neighborhood, whenever my neighbor starts mowing his lawn, I always go, gosh, I got to get out and mow my lawn too. You find that when you model good behavior, folks will start following. And the board should be setting the standard and the expectation of modeling that good behavior so that the association can grow and be an effective community for preservation of the community and the investment that the members have made. And so just keep doing what you've been doing. I don't know that I'm speaking to people that need a whole lot of advice, but I would say just keep attending our programs. The educational seminars that CAI offers are extraordinary. They don't always answer all your specific questions, but they give you the tools to be able to identify the problems and address them.
Yeah. And a recommendation that I have to boards, and it's going to become increasingly more and more relevant. We just talked about non-functional turf tonight, you know, today in the questions. We're going to have electrical infrastructure changes that are coming. And, you know, the reality is that common interest communities, you know, the one that I live in, it was created in the, you know, early 90s, late 80s. Now we're like 30-something years into the community, and whether it's a planned development, a condo, a stock co-op, or whatever, more and more of the larger components of communities need to start being evaluated. And the boards of directors that are really planning long-term, not just reacting short-term, it's going to become more and more essential, because these large systems, whether it's roadways and pipes, whether it's siding and roofs and these types of things, they're going to be expensive projects. And the last thing that a community wants to be confronted with is an emergency assessment, because our pipes are so deteriorated. We have to get them replaced this year. We haven't really planned for that. And now we're having to do emergency special assessments that are like, you know, thousands and thousands of dollars per homeowner, and we're having to get loans. And that is a really, really stressful position for boards to have to be in, and for your homeowners to have to be in. And some communities kick those cans down the road far past what's appropriate, going past that duty of care stage. And just because of, you know, the age that a lot of community associations are at, or they're approaching, it's really incumbent on boards to start sitting down with all those experts that you're entitled to sit with and understand, what do we really need to know? One of the things that boards can sometimes have this mentality, and it's the wrong one, of if we don't get the information, then we can't be held you know, responsible for not having violated or followed it. And that's actually the opposite of what the board's duty is. You have that duty to engage in reasonable investigation. And I really encourage boards to start having those conversations with your community management team, with the vendors that they recognize. Do not shy away from getting the information, because it's a lot easier to say, all right, we're going to start a 5-year plan where we're evaluating what we're going to need to do. We're going to be able to have conversations with the homeowners, and we're going to be able to implement this in a non-frenetic manner that makes it hard on you, you know, unit sales and values. And so you know, this is one of the biggest things, like the Foundation for Community Association Research. They did a study a couple years ago that identified like 80% of HOAs across the nation, so this isn't just in California, suffer from severe, you know, deferred maintenance issues. And so it's, I mean, this is something that a lot of community associations are confronting, and the sooner that the boards can actually start having, you know, reasonable understanding of what they're looking at and the costs, you can start doing the hard choices that are necessary. But, you know, none of us wants to have scenarios like the Champlain Towers that fell in, you know, Florida. And so these are just things that I really do encourage boards of directors to start investigating, and then having those conversations amongst themselves, and certainly with their community members, on how are we going to plan for it? How are we going to pay for it? That's probably the wet noodle to end on. So let's do something a little bit more fun.
We have some educational items coming up, obviously. we have a coffee break actually in 2 weeks on February 6th, where one of our vendors will be talking about roofs and leaks, I believe. And that is free. If you are a homeowner leader to attend, it's virtual over Zoom, 30 minutes. You also get another $5 Starbucks gift card. You are getting one today. You might actually already have it in your inbox. And then we have our educational luncheon in person on February 15th. And Jasmine's actually one of our speakers. We're going to be talking, about dealing with difficult situations and micromanagers, so it's going to be good. And then we typically have a luncheon every month, so if you are interested in getting our emails and want to come out and participate, join a committee, reach out to us. But yeah, we're preaching to the choir because you guys are the ones who care about your education, because that's why you're here. So all right, I got no other questions. I can't believe it. Normally this one goes over by like 20 minutes.
All right. Well, I thank everyone for attending today. It was a great program. I'm hoping you took away something today from what we've spoken about, and wish you all just a wonderful weekend and a wonderful year. So
Thank you, speakers. Good job.
thank
Thanks,
you.
everyone.
Good job, guys. Bye.
Thank you all.